And we start this broadcast with some breaking inputs coming in. This is as far as the government versus Twitter confrontation, which has peaked, which has intensified. Now, what's happened is that Twitter has approached Karnataka High Court challenging the takedown orders. We're talking about the removal of content from Twitter, which the government had asked the social media giant. But now Twitter has moved Karnataka High Court. Under the new IT rules, the social media giant was supposed to comply with it. But now what's happened is that this is a new face-off between the two. Remember, the centre recently granted one last warning to Twitter to comply with the takedown notices under Section 69A of the IT Act.
Alleging abuse of power by Indian officials, Twitter has moved the Karnataka High Court against the Indian government's order as per reports. Twitter was warned by the Indian IT Ministry of criminal proceedings if it does not comply with its content order. The IT Ministry had given the social media platform time till July 4 to comply with its order. Otherwise, Twitter is going to lose its status, which means Twitter itself will be liable for any sort of comment or post that's been made in Twitter itself. Now, day after the deadline, Twitter has took to legal recourse. And now, as we know that on 27th of June, the IT Ministry had issued its last order to Twitter, but Twitter has failed to comply with its order. IT Ministry specifically has maintained that the Twitter has to appoint a grievance officer, a chief compliance officer out here in India, but clearly they have failed to do so. And a day after the deadline, they have took to the Karnataka High Court to take action against the Indian government.
सोशल मीडिया एक बहुत ही पावरफुल मीडियम है, हमारी लाइफ में आज बहुत बड़ा प्रभाव है। इसकी अकाउंटेबिलिटी कैसे हो, ये क्वेश्चन दुनिया में सब जगह अभी एक बहुत ही वैलिड क्वेश्चन बन चुका है। सोशल मीडिया को अकाउंटेबल करना ज़रूरी है। कैसे अकाउंटेबल करें? सबसे पहले सेल्फ रेगुलेशन, किस तरह से खुद ही कुछ ऐसे कंटेंट जिन कंटेंट से सोसाइटी में एक हार्मफुल इम्पैक्ट आता है उसको खुद ही दूर करें। फिर इंडस्ट्री रेगुलेशन, फिर गवर्नमेंट रेगुलेशन। तो हर तरह का एक ऐसा इकोसिस्टम, ऐसा थॉट प्रोसेस अभी बन रहा है दुनिया में सब जगह और देश में भी, अपने यहाँ भी, कि सोशल मीडिया शुड बी अकाउंटेबल।
Right, so there you heard Union IT Minister there saying that regulation is very important. The first step would be self-regulation, then industry regulation, and then government regulation in order to make social media accountable. So the big update that we are getting for you is that Twitter is seeking to overturn some Indian government orders to take down content on social media platform. This is the latest. Remember, this is also an example of how things are not going smoothly between the centre and Twitter. This goes on to show that the confrontation between Twitter and the government has peaked. Remember, Twitter has been asked by Indian authorities to act on content as far as misinformation is concerned, and the centre had asked Twitter to remove that content, but this is the latest. Twitter has moved Karnataka High Court in order to seek a judicial review. It's believed, as per sources, that Twitter is arguing that the orders to remove content from the social media platform fall short of the procedural requirements of India's IT Act. We have to wait and watch the specifics as to what specifics is Twitter talking about. However, they have cited the IT Act and they have said that the order to get the content removed on social media, on Twitter, there are some procedural shortcomings, there are some issues, requirements that the orders do not fulfill. So this is the big update that we are getting for you. Remember, the IT Act in question, the IT Act that we are referring to, allows the government to block public access to content in the interest of national security. So this was the biggest argument by the that asked Twitter to remove some content from its platform, citing misinformation, and they said that under India's IT Act, this content has to be removed. But now Twitter has moved Karnataka High Court in order to overturn that decision. All right, for more on this, I'm joined by Supreme Court Advocate N.S. Napinai on the broadcast. Napinai, thank you so much, ma'am, for speaking to Mirror Now and making time on this very important conversation that we are having. This is another trigger where the confrontation between the centre and Twitter has peaked because Twitter has moved Karnataka High Court seeking to overturn this decision. How do you view this development?
The report seemed to indicate that Twitter seems to be seeking some kind of a blanket order against all the blocking or removal orders that have been issued by the government. My take on it is, whilst it is open for Twitter to approach court for redress, it can do so only with respect to each of the orders that have been passed by the government, directing Twitter to take down content specific to the content. It cannot be a blanket order. Because if Twitter is seeking a blanket order from Karnataka High Court, in effect, what it's trying to do is to overturn the decision in Shreya Singh's case by the Supreme Court, which has upheld the constitutionality of Section 69A IT Act.
Okay, but you know, both sides, both the government and Twitter have cited the IT Act. Of course, IT Act gives the government the power to seek the blocking and removal of content from social media. But here, Twitter is also saying that there are certain requirements that the orders do not fulfill. However, it's not clear what specifically Twitter is talking about. But do you think there is this scope, there is this window which the option which Twitter can use and exploit at this moment in order to not remove content from its platform?
As I said earlier, if Twitter felt that any of the orders were excessive, it was open to them to contest each of those orders. To do so now as a blanket request at a time when the extended period is over, effectively as of yesterday, or one could say today, that may or may not be sustainable. But having said that, here is my take, and this is something which comes from precedent. In about 2010, if I'm not mistaken, there was a public interest litigation which was filed seeking a blanket stay or blanket order for removal of all forms of pornography. Even in that, the court held, it was struck down, and it was held that if the petitioner had an issue with a specific site or a specific content, it was open to them to seek redress in law or to approach courts, but to seek blanket orders would be stifling of free speech and expression, etc.
Absolutely.
So in effect, by Twitter seeking a blanket order, I feel that it may not be sustainable. If they really had a problem with any specific order in terms of it being excessive or otherwise, it was open for them to go to court on that, and it should have been done in a timely manner. It can't be done at this belated hour. Of course, they can still do it, but how far they'll succeed is still moot.
All right, thank you so much, N.S. Napinai, for speaking to Mirror Now. We'll have to wait and watch how this transpires eventually in the court, because the centre has already given its last warning to Twitter to comply, or Twitter stands to lose its intermediary status. We'll have to wait and watch how this entire saga plays out.